So the Supreme Court just issued a 6-3 decision last week, which restricts an individual's ability to sue ATF agents who violate Second Amendment rights. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit the like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website linked down below. And thank you again, SDI, for sponsoring this video. So like I said in the intro, the Supreme Court just issued a 6-3 decision last week in a case that closes the door for individuals to sue federal agents, like those in the ATF, who violate constitutional rights, including Second Amendment rights. The case and opinion we'll be talking about in this video is Egbert v. Bull, and it's a case coming out of the Ninth Circuit. This case involves whether a plaintiff has the right to sue federal officers for First Amendment retaliation claims, or for allegedly violating an individual's Fourth Amendment rights while engaged in immigration-related functions. Now, although the facts of this case relate to immigration agents, the decision has broader impacts on whether people like me and you can sue federal agents for other constitutional violations, including Second Amendment violations that maybe agents from the ATF engage in. And that is why this decision is so important. It really involves whether or not we as individuals can sue individual federal agents like those in the ATF when they violate our 2A rights. Now, some background on this case and how it wound up before the Supreme Court for this decision. The plaintiff in this case, Mr. Bull, runs the Smugglers Inn on the border between Washington and Canada. The area is known as a hotspot for smuggling people, drugs, money, and more. Mr. Bull was actually a confidential informant who also profited from persons crossing the border illegally. Mr. Bull informed a Border Patrol agent, Mr. Egbert, who is another party in this case, that a Turkish man was arriving in Seattle and was scheduled to be transported to his inn. That afternoon, the agent, Mr. Egbert, saw Mr. Bull's vehicle with the license plate Smuggler, and he saw it return to the inn. The agent then followed Mr. Bull onto the inn's property to check the passenger's immigration status. Mr. Bull told Mr. Egbert to leave the private property, but the agent wouldn't, and then allegedly the agent lifted Mr. Bull, threw him against a vehicle, and also threw him on the ground. Now, the agent eventually left the property after determining that the passenger's immigration paperwork was in order. In response to the incident, Mr. Bull lodged a grievance with the agent's supervisor, alleging excessive force. After filing the grievance with Egbert's supervisor, Bull was then contacted by the IRS for a tax audit and also state authorities who investigated his activities at the inn. Mr. Bull then filed an administrative claim asserting that the agent retaliated against him by reporting him to the state authorities and also to the IRS. These claims were obviously denied by the federal agent, but because of this, Mr. Bull then sued Mr. Egbert for damages, alleging claims under the Fourth Amendment and also under the First Amendment. On review, a district court declined to extend Bivens to these claims, but a Ninth Circuit Court 3-judge panel reversed, finding that you could sue immigration agents for First Amendment and Fourth Amendment violations under Bivens. Egbert, the immigration agent, sought review from an en banc panel in the Ninth Circuit, but that review was denied. That led to him seeking Supreme Court review of the Ninth Circuit's decision, and that leads us to this opinion here. Now, for those of you not aware of what Bivens is and what role it plays in this case, Bivens is a 1971 Supreme Court case where the court held it had authority to create a cause of action under the Fourth Amendment against federal narcotics agents who allegedly used unreasonable force while conducting a warrantless search and seizure. The court later created Bivens types causes of actions for a congressional staffer's Fifth Amendment sex discrimination claim and a federal prisoner's Eighth Amendment claim for inadequate care. Since then, the Supreme Court has declined to recognize additional causes of action because in all but the most unusual circumstances, creating a cause of action, they claim, is the job of Congress, not the courts. The belief is that Congress is generally better suited to weigh in on economic concerns, administrative costs, and the impact suits will have on governmental operations. These types of causes of actions and creating cause of actions have fallen out of favor with the Supreme Court, but the Supreme Court has not dispensed with Bivens altogether, but new causes of actions are generally disfavored by the Supreme Court. So what was at stake in this case is whether the Supreme Court was going to allow a cause of action against federal immigration agents for First and Fourth Amendment violations, or the question was whether or not the Supreme Court was going to further close the door on these types of Bivens claims. Well, in a 6-3 opinion authored by Justice Thomas, the Supreme Court reversed the Ninth Circuit's finding. In their determination, they found that an individual could not sue an immigration agent for First and Fourth Amendment violations. The Supreme Court, in this opinion, condensed the issue down to really one single question, and that was whether there is any reason to think that Congress might be better equipped to create a damages remedy. It might be better to do that than the court itself. Later in the opinion, the majority describes this singular new question as whether there is a rational reason, even just one, to think that Congress is better suited to weigh the costs and benefits of allowing a damages action to proceed. Justice Gorsuch, in his concurring opinion, agreed with the majority's new single question approach, which asks whether Congress is better equipped than courts to decide whether a damages action should be available. However, Justice Gorsuch, in his concurrence, came to the conclusion that the answer to that question is always yes. He believes Congress is always better equipped, and therefore, since the answer is always yes, the court here in the opinion should have stated that Congress has the exclusive power to create new causes of action and end these types of lawsuits that want to create new causes of action against federal agents. Now, the majority's decision in this case is unsurprising, especially since the Supreme Court has rejected every Bivens claim since 1980. However, this opinion is unique in the fact that it will render new damage actions near impossible from here on out. That includes any Bivens claims against ATF federal agents who violate due process rights, search and seizure rights, and overall engage in Second Amendment violations. Now, I'm not aware of any cases off the top of my head that bring Bivens claims against the ATF for Fourth Amendment violations or even Second Amendment violations. However, that was always an avenue that was potentially out there. Even if it was a disfavored one by the court, and maybe if the court didn't like it, it was still out there. But now any new causes of action for those types of constitutional violations against the ATF agents is pretty much closed from here on out. We have a clear signal now that the Supreme Court doesn't like that, and the whole question they're going to say every single time is whether or not Congress is better suited to determine whether or not a cause of action should be valid against the ATF, and they're just going to pretty much defer to Congress on these types of issues from here on out. This is one of those situations where if I'm being intellectually consistent, I think the court got this right, but it still sucks. I agree that courts should not have the power to simply create new causes of actions whenever they want. Instead, Congress is the one that has the power to create new laws, new causes of actions through the legislative process. This is similar to how we criticize the ATF for creating new rules whenever they want, when we all know the legislative power lies with Congress, not with the ATF as an agency. But unfortunately, where the rubber hits the road is that this results in no new causes of action against ATF federal agents will be upheld by the court unless and until Congress creates a cause of action where they say, yes, individuals can sue ATF agents for due process violations or Second Amendment violations. And unfortunately, in my opinion, there is no chance of anything like that ever happening, at least anytime soon. So this is an interesting case with a lot of different concepts that I have not got to cover on this channel yet. I am by no means an expert on Bivens or case law or anything like this, but I just want to give my insight on what impact I believe this decision by the Supreme Court will have on the Second Amendment context. If you guys have any questions, go ahead and comment down below and I'll try to answer best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping us reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is with Built Bar Arms Scholars, and the station will be made Tam Bar Arms Scholars.